Hello everyone, this is Devika Sharma and I bring you the 20th episode of SCC Online Weekly Rewind with all the important and interesting stories of the week gone by. Emphasizing the importance of following proper procedure of ratification for constitutional amendments where so required, the Supreme Court delivered a major ruling this week. A 3-judge bench held that the Constitution 97th Amendment Act 2011 is partly ultra vires the Constitution. Among other things, the 97th Amendment Act has inserted Part 9b in the Constitution. The court has held that Part 9b is unconstitutional insofar it is concerned with the subject of cooperative societies, for want of the requisite ratification under the proviso to Article 368(2). However, at the same time, the court by a majority of 2:1 followed doctrine of severability in declaring that the same Part 9b is operative insofar as it concerns multi-state cooperative societies both within various states and in union territories. Justice R.F. Nariman and Justice B.R. Gavai formed the majority, whereas Justice K.M. Joseph penned a separate opinion, dissenting partly with the majority. He expressed inability to concur with the view on the application of doctrine of severability. Whether the power of a court under Section 34 of the Arbitration and Conciliation Act 1996 to set aside an award of an arbitrator would include the power to modify such an award. Answering this interesting and important question in the negative, the Supreme Court said that if one were to include the power to modify an award in Section 34, one would be crossing the Lakshman Rekha. While laying down this law, the Supreme Court reversed the Madras High Court judgment which had ruled that at least insofar as arbitral awards made under the National Highways Act 1956 are concerned, Section 34 of the Arbitration Act must be so read as to permit modification of an arbitral award made under the National Highways Act so as to enhance compensation awarded by an arbitrator. In another case, while closing the suo motu case regarding Kanwar Yatra during pandemic, the division bench comprising of Justice R.F. Nariman and Justice B.R. Gavai directed the authorities to be cautious towards public health and safety. The bench stated, "We may only remind the authorities at all levels to have regard to Article 144 of the Constitution and ensure that untoward incidents which directly affect the lives of the public will be looked upon sternly and prompt action will be taken immediately." Giving a major relief to the home buyers, the Supreme Court held that rights of a subsequent purchaser are the same as that of an original allottee in a housing project. The court said that in the event the subsequent purchaser claims refund on an assessment that he too can, like the original allottee, no longer wait and face intolerable burdens, the equities would have to be molded. Let's move on to the High Courts. Whether a promise made by a chief minister to its citizens is enforceable. Well, the Delhi High Court says yes, it is. Justice Pratibha M. Singh pronounced a one-of-its-kind ruling. The court said that the law has evolved the doctrines of legitimate expectation and promissory estoppel to ensure that promises made by the government, its officials, and other authorities are not broken and are in fact judicially enforceable, subject to certain conditions. The High Court expressed that a statement given in a consciously held press conference in the background of the lockdown announced due to the pandemic and the mass exodus of migrant laborers cannot be simply overlooked. Proper governance requires the government to take a decision on the assurance given by the Chief Minister, and inaction on the same cannot be the answer. In the backdrop of this decision was a press conference held by the Chief Minister of Delhi during the ongoing COVID pandemic, where he gave a solemn assurance that the government would take care of the tenants who are unable to pay the rent due to the poverty. Can a girlfriend or concubine of husband be prosecuted for cruelty under the Penal Code 1860? Andhra Pradesh High Court held that a girlfriend or concubine, being not connected by blood or marriage, is not a relative of the husband for the purpose of Section 498A IPC. The Allahabad High Court dealt with the case of an accused who committed murder in most brutal and barbaric manner of his wife and 4 minor daughters to pave way to marry another lady. Not only this, but he also chopped off various parts of their bodies and inflicted severe wounds. In such above background of the case, the High Court upheld the trial court's decision of awarding death penalty to the accused. Court expressed that the accused is a menace to the society and therefore imposition of lesser sentence than that of death sentence would not be adequate and appropriate. Recently, the Punjab and Haryana High Court addressed the plight of a 72-year-old widowed mother who had been ousted from her house by her son and was given beatings. The court observed that it is often seen that after receiving property from their parents, children abandon them. In such situation, the Maintenance and Welfare of Parents and Senior Citizens Act 2007 is an enabling lifeline for such old, aged parents and senior citizens who are not looked after by their children and become neglected lots. Further, the court held that the children are expected to look after their elderly parents properly, which is not only a value-based principle but a bounden duty as enshrined within the mandate of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. In a case with very disturbing accusations, the Punjab and Haryana High Court rejected the bail application of the applicant accused of committing an act of sodomy to an 8-year-old child. The bench stated that accused has spoiled the life of a young child by his hateful acts. Petitioner comes out to be a sex maniac, himself a teenager, indulging in perverse sexual acts. His conduct cannot be taken lightly, since if he is released in bail, he may victimize several other innocent children and is a grave threat to the society. It was alleged that accused had attempted to commit unnatural sex with a child of young age of 8 years, making him undergo nightmarish and traumatic experience which may haunt him for the rest of his life. Expressing concern over violence against married women, the Kerala High Court rejected the bail application of a doctor and his family accused of dowry demand and cruelty against his wife within 7 months of marriage. Calling matrimonial homes the most dangerous place to live due to harassment, abuse and torture, the bench remarked that the number of cases of attack towards married women in our country is alarming. Though stringent laws are there and the same has to be stopped forever, the court observed that harassment, abuse and torture, both mental and physical, towards married ladies are increasing day by day in our country. To pressurize them to bring more wealth to the family of the bridegroom to improve their financial situation. Though so many cases are being registered against husbands and in-laws, there is no change in the attitude of the society towards married women and family members. The Guwahati High Court stayed the order of the State Executive Committee of Arunachal Pradesh, whereby non-vaccinated persons for COVID-19 were being discriminated for the purpose of permit to enter the state for developmental works in both public and private sector. Additionally, the court stated that if the sole object of issuing the impugned order was for the containment of COVID-19 pandemic and its further spread in the state of Arunachal Pradesh, the classification sought to be made between vaccinated and unvaccinated persons was prima facie a classification not founded on intelligible differentia, nor it was found to have a rational relation nexus to the object sought to be achieved by such classification, namely containment and further spread of COVID-19 pandemic. Expressing shock over an incident of hate speech in a public gathering, the Court of Judicial Magistrate Patodi Gurugram dismissed bail plea of Ram Bhagat Gopal, who had allegedly delivered hate speech, instigating abduction and killing of girls of a particular community. The court observed that if right of freedom of speech is allowed to be used to spread hatred amongst the people based on religion, caste, etc., then the very basic nature of the constitution and Indian society will be shattered, and the country will lose its true spirit and soul. Further, the court stated that conscience of the court is utterly shocked while seeing the actual incidents which took place at that time in video recording. It seems that now a normal parent would tell stories to their children that there used to be a time when talks of hatred or the religious intolerance in our society used to be seen as a sign of diminishing social values. In a significant ruling, the European Court of Justice held that prohibiting Islamic headscarf and any visible sign of political, ideological, or religious beliefs does not constitute discrimination on the grounds of religion. Moving on to the legislation updates, the International Financial Services Centres Authority has notified the International Financial Services Centres Authority issuance and listing of securities regulations 2021 to ensure that capital markets in IFSCs support the financing of innovative business models and also for the issuance and listing of securities by startups, small medium enterprises and special purpose acquisition company. The Ministry of Finance has issued a memorandum on revision of Dearness Allowance to the central government employees. The Dearness Allowance has been enhanced from 17% to straight 28% of the basic pay for the employees with effect from July 1st, 2021. IBBI has released Form CIRP 8, which as per Regulation 40B of CIRP regulation, every resolution professional is required to file intimating details of his opinion and determination under Regulation 35A by 140th day of the insolvency commencement date. The Form CIRP 8 is required to be filed for all corporate insolvency resolution processes ongoing or commencing on or after 14 July 2021. For the format of Form CIRP, read our story on SCC online blog. SEBI issues circular on block mechanism in demat account of clients undertaking sale transactions after extensive consultations with depositories, clearing corporations and stock exchanges to provide a mechanism of block in the demat account of clients undertaking sale transactions. Read the complete details on SCC online blog. This is Devika Sharma signing off for this week. Please do subscribe to our YouTube channel and other social media handles to get more such updates.